Start whenever. Okay, great. Yeah. All right, welcome everyone. We're going to go ahead and get started. So please feel free to continue to enjoy your lunch, and I'm going to help set the table here. And again, just want to welcome everyone for joining us for the penultimate session for the program on education policy and governance. My name is Payman Rohanafard. I've been a guest lecturer here at Kennedy School with Professor Peterson for about 7 years now. My role today is to help moderate the conversation with Justice Bolick, who I'll introduce in a moment. My background is mostly in K-12 systems work. So I was a teacher in New York City, eventually worked in the central office in the Bloomberg administration, became a superintendent in New Jersey, and led a district in the southern part of the state in a city called Camden, for those of you who know Jersey. That was sort of in a state takeover turnaround setting. Did that for a number of years and now work in the education technology world, co-founded an organization that helps with master scheduling, for those of you that know anything about scheduling. And so we have one last session just to share for those who want to continue to participate in these, and that's actually in 2 days. So Thursday, November 21st, and that session is going to be led by Stephen Bowen, who's the former Commissioner of Education for the state of Maine. And the focus there will be on lessons for policymakers from 4 decades of school reform, which I think will be fascinating. Today, we are incredibly privileged to have Justice Clint Bolick joining us. And so Justice Bolick was appointed to the Arizona Supreme Court in 2016. And in 2024, he won re-election. His current term ends in January of 25.
No, that is not.
Okay.
That is not true. Antonio thought it was, but having gone through this incredible retention election, if I had to leave in January, that would totally, I apologize for using this word suck, but it actually goes till my 70th birthday, which is the day after Christmas, 2027. So.
All right. I'm glad we cleared that up for the record. Prior to joining the court, Justice Bolick litigated constitutional cases in state and federal courts from coast to coast, including the U.S. Supreme Court. Among other positions, he served as vice president for litigation at the Goldwater Institute and as co-founder and vice president for litigation at the Institute for Justice. He has litigated in support of school choice, private property rights, freedom of speech, and federalism, and against racial classifications and government subsidies. He has a JD from University of California, Davis, and his Bachelor of Arts from Drew University. Thank you for joining us here today. I'm going to turn it over to you. We'll ask some questions after his remarks, and then we'll open it up to this group.
Thank you so much. It's great to be back in the Kennedy School. It is great to be back with Professor Peterson, who was our very, very first expert witness in one of our school choice cases in Milwaukee, where it all began. And so we have known each other now for over 3 decades. And I've had the opportunity to come to the Kennedy School on several occasions and really love it. I'm looking forward to your questions later on. And also was very intrigued by your background, because I had actually planned to be a school teacher, and it was my student teaching experiences in northern New Jersey that catapulted me into a different line of work, namely being a lawyer, because I became convinced that systemic change was necessary, and education, for better or worse, has been the subject of a tremendous amount of litigation. New Jersey probably being the first state where that was the case. And I ultimately concluded that I could do more for education in the courtroom than in the classroom, which is a kind of a sad commentary on our times, and one that I hope will no longer be the case in the not too distant future. But what I am going to talk about today is the intersection of the 2 religion provisions of the Constitution, and use school choice. School choice has been a major part of the jurisprudential foment in this area. And so I will illustrate these concepts over the course of my talk. When I was appointed to the court in 2016, I was one of 7 candidates who was sent to Governor Doug Ducey. And I was, by luck of the draw, I was the first person he interviewed over the course of his 8 years as governor for a Supreme Court position. And I knew him, so, we exchanged pleasantries and we sat down and he said, well, we've got 75 minutes and I've got 50 questions. So let's try to get through as many of them as possible. To say that was an intimidating moment is an understatement. And his questions were, the kinds of questions you would hope that prospective judges would be asked. Some of them were kind of just fun, but nonetheless insightful, like what's on your book stand right now, who's your favorite justice and why, those sorts of things. But one of the first questions he asked me was, which is the most important of the 2 religion clauses in the First Amendment and why? I had never, by the way, I teach constitutional law now at ASU. And so I'm really used to pondering constitutional questions, but I had never gotten that before. And so I thought about it for a moment. So the First Amendment, for those of you for whom it is not totally fresh on your mind, begins with the words, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So they're referred to as the Establishment Clause and the Free Exercise Clause. And I thought about it for about the 11 seconds that I had. And I finally said the second provision is more important. And the reason is by the first provision, that provision was aimed at a finite problem that existed around the time of the founding, and that was state-sponsored churches or national government sponsored churches. And note that the words of the provision begin with Congress shall make no. At the time, states were free to establish their own religions, which when people think about that now, it would just seem absolutely absurd, but it was not particularly atypical. But the idea of the national government establishing a religion was precisely a rebellion against England doing that. And a country founded on the idea of religious liberty could hardly flourish if the government would be able to establish a religion. Now, that problem has been arrested, and we have not seen that in the states or the federal government for well over a century. And by contrast, we see every single day clashes involving the free exercise of religion. So my response was that the second provision was more important, at least today, to the framers. They put establishment first. And I think the reason they put establishment first was because you could not have the second if you had an established religion. But today, in my opinion, it's not so much of a problem. Then why do we hear so much about it? Why do we have so many cases involving the establishment of religion? Well, for a century and a half, nothing in the Bill of Rights applied to the states. After the Civil War, the 14th Amendment was passed. It, among other things, guaranteed the privileges or immunities of citizenship to the citizens of the several states. The reason being that the states were the primary sources of tyranny in our country, and that wanted the framers of the 14th Amendment wanted to put a stop to that. In my view, the Bill of Rights should have been incorporated as to the states instantly, the moment the 14th Amendment passed. But it actually took the better part, many, many years for parts of the Bill of Rights to be incorporated against the states, starting in the 1920s with freedom of speech, and then in the 1940s with free exercise and establishment. Only 2.5 decades ago, the Second Amendment was incorporated. So it's been a very, very gradual process. So in the 1940s, there were a number of cases involving both free exercise of religion and establishment of religion. And in the 1940s, the idea of the Establishment Clause had grown dramatically. This actually traced its origins to a letter that Thomas Jefferson wrote. Many of you who are historians have heard about this, where in a letter he used the term wall of separation, that there's a wall, that the Constitution ordains that there be a wall of separation between the church and state. And this metaphor became a very, very powerful metaphor. Ironically, Jefferson used it as a warning against the invasion of religion by the government, not vice versa. But by the 1940s, this term had become a litigation strategy designed to limit the amount of support the government could provide to religious institutions. And so by the 1940s, every single member of the Supreme Court interpreted the Establishment Clause to require a wall of separation between the church and the state. With regard to education, with regard to the Free Exercise Clause, and this is an issue that you will see in almost every free exercise case that goes to the U.S. Supreme Court. Early on, the Warren Court, very broad view of both clauses. The Free Exercise Clause, in a case called Sherbert, the court held that any time the government imposed a burden on religion, the government had to justify it as a compelling government interest, and that the regulation was narrowly tailored to accomplish that. A few decades later, that decision was essentially overturned in a decision written by Antonin Scalia, who most people think of as very pro-free exercise of religion. But in a case called Smith versus Employment Services, he said, no, we have this wrong. If the government has a neutral regulation of everyone, and it has an incidental effect on religion, then it's really the burden is on the religious person to show that this is an excessive regulation. As a result of that, free exercise claims became much, much more difficult to prove. Congress responded by passing the Religious Freedom Restoration Act, which restored the Sherbert test. It was struck down by the U.S. Supreme Court, who said we get to say what the First Amendment means, not Congress. And then a number of states passed mini religious freedom restoration acts. I don't know whether Massachusetts has one, Arizona does, that provide greater religious freedom than the First Amendment does, as currently interpreted by the U.S. Supreme Court. Ironically, and this happens all the time, it is now conservatives who are pushing to get rid of the Smith test, and liberals who are protecting it. On the Establishment Clause, though, we had a series of cases in the 1940s, including the most famous of them called Everson, which applied the wall of separation metaphor. It upheld free bus transportation for parochial school students, but said it was doing so only because this was a broad-based program available to everyone. But it held that any aid that was directed toward religious schools or those who patronize them would be unconstitutional. setting the stage for a very difficult time for the idea of school vouchers that would arise 50 years later. A number of cases came after that. One that you may have heard of was a case called Lemon versus Kurtzman, which had a three-part test for aid to religious organizations. In the subsequent Nyquist decision in 1978, the court held that aid to parochial schools and those who patronized them was unconstitutional. And this was the construct that existed when school vouchers began in the 1990s. It was a very, very unfavorable constitutional environment, very, very much an uphill battle. But the nature of school choice evolved. There were two earlier forms. One was what was called paroch aid, and that was designed to rescue inner city Catholic schools, which were falling by the wayside as more and more Catholics moved from the city to the suburbs and the financial base began to erode. The second, and much more nefarious, was as a response to desegregation. A number of southern states passed voucher programs that were designed to allow white families to go to segregated private schools if they could no longer go to segregated public schools. That was struck down as well. So vouchers had a less than pristine pedigree and a great deal of constitutional doubt attached to them. So when modern vouchers emerged in the 1990s, they took a very, very different form. And that was, as I would describe it, as a life preserver for kids in failing urban public schools to allow them to escape those schools and go to better performing public schools. The very first program in Milwaukee in 1990 was tiny. It was limited to 1,000 kids. All of them had to be low income. The schools that accepted the vouchers had to accept them as full payment of tuition. And critically, they were limited to non-sectarian private schools. Nonetheless, they're attacked under the state constitution. They survived, they flourished, and then the program was expanded to include religious schools. And so we had the religion issue squarely presented, not just under the First Amendment Establishment Clause, though. There are in about 2/3 of the states provisions called Blaine Amendments. And the Blaine Amendments were born in the late 19th century and early 20th century as part of a response to immigration, and not a welcome everybody response, but a do not pollute us with your values and your religion type of response to immigration. At the time of that these amendments were passed in state constitutions, public schools were Protestant schools. You would go to school and you would see pastors teaching classes, running the schools, and so forth. And the immigrants that were coming in at the end of the 19th century were primarily Catholic immigrants. And along with them came their Catholic schools. And states responded with a variety of efforts to force kids to go to private schools. And one of the efforts were these Blaine Amendments, which were designed, generally they say that the following, they're often different, but generally they say no public aid shall be provided for sectarian institutions. Today, if you look up the word sectarian, you will find that it is a synonym for religious. In 1900, if you looked up the word sectarian, you would find that it was a synonym for Catholic. And so these laws were designed, these amendments were designed to prevent any use of government aid for Catholic schools specifically. And essentially, it was the Protestants trying to maintain their hegemony over public schools. Fast forward to today, the school voucher programs then not only have to pass the Establishment Clause test, but they also have to survive Blaine amendments in roughly 2/3 of the states. So to make a long story short, they do. In Wisconsin, for example, both a Blaine Amendment challenge and an Establishment Clause challenge. The Blaine Amendment challenge fails because the court says this is not aid for religious schools, it is aid for students. And that was our legal strategy as we were defending these programs. If these cases are perceived as being about religion, we lose. If they are perceived to be about education, we win. And that first experiment in Wisconsin succeeded. In Arizona, we had a voucher program that was struck down by the court that I now sit on under the Blaine Amendment. And there, the court held this is unconstitutional under our amendment because there's only one destination for the money, and that is private schools. Private schools are overwhelmingly religious, therefore they violate our constitutional provision. But the court had a very important caveat. And they said, if this aid was available for a variety of purposes, not just private school tuition, it might be permissible. That was the day that the idea of education savings accounts were born. Because we thought, if we get this struck down, we need to come back with something. And the idea, and frankly, from a policy standpoint, I was not focused on policy. I was focused on law. And but from a policy standpoint, I think education savings accounts are a much preferable alternative because you can use it to personalize education for your child. Your child is disabled, they can get educational therapy. You can get computer software. You can buy discrete products from public schools like sports or chemistry labs, that sort of thing, or private school tuition. And for low-income kids, it has the added benefit in some states that if you don't use all of your money, you can save it for college. So you've got an inbuilt college education fund with education savings accounts. They get challenged under our Blaine Amendment and get upheld. And so the idea of education savings accounts, which is probably today the more popular idea as opposed to vouchers, is born. We go to the US Supreme Court in a case called Zellman versus Simmons-Harris. We've been building jurisprudence over time to move it away from the wall of separation as best we can. And we win by a 5-4 margin. And we win on the basis of two principles. One is the principle of neutrality, and that is that the state should neither discriminate in favor of or against religious schools. And second, the idea of what's called true parental choice. And that is religious schools are only one of the options available. This case happens to involve Cleveland. Cleveland invited suburban public schools to participate. None of them did. Charter schools were one of the options, and so on and so forth. So the court upholds this. So from there, two decades pass, and Blaine amendments and other state constitutional prohibitions continue to be a problem for school choice. So we've won the battle in the US Supreme Court under the Establishment Clause. The court continues to evolve the Establishment Clause. And one of my favorite cases, because it's so interesting in so many ways, was a case called American Legion versus Americans United for Separation of Church and State. Can't imagine two more polar opposite parties in a case. And it involves, has anyone ever been to Bladensburg, Maryland by chance? So you're driving through suburban Maryland, and especially at night, this is stunning. You're driving along, the night is black, and suddenly there is this massive cross that is lit up at night, and it is like, holy cow, where did that come from? And the first time I saw it, I'm sure we were lost, as we always would when I lived in DC. Going to Maryland, get lost. But in any event, I see this in the night sky. And the first thing, being a constitutional nerd, that I think of is violation of the Establishment Clause, right? So the court takes this case up and it holds, no, this is not a violation of the Establishment Clause. And that is because we now apply two tests under the Establishment Clause: coercion and history and tradition. Guess what? History and tradition under the Establishment Clause is essentially a way of saying anything goes, because our history and tradition is permeated with religion in the public sphere. In God we trust, right? Our coins, saying a prayer before public meetings. There's hardly a tradition, hardly a tradition that you can find that is where that is hostile to religion. So the court has moved dramatically from Zellman versus Simmons Harris, whether that's the right thing or not. And in fact, in one of the most recent cases, Justice Sotomayor, in fact, the last one I'll talk about, is she said that separation of church and state has been reduced to a constitutional slogan. And in my view, it always was a constitutional slogan. It's not in the Constitution, but nonetheless, the evolution in this area of law has been more pronounced than any other I've ever seen since Plessy to Brown versus Board of Education. And it's been in the course of since the 40s to today. But what we're seeing now is increasingly a clash between the Free Exercise Clause and the Establishment Clause. One case that many of you probably read about involved Coach Kennedy, who led a prayer after football games. And the court split over that, with the dissent arguing that this was coercive, that the kids felt obligated to do it. And there's no question, if a practice is coercive, if the government is coercing you to participate in religion, that still is unconstitutional, still a violation of the Establishment Clause. But a majority said, no, this is not coercive. This is the coach exercising his free exercise rights. And the state may not discriminate against him. So, fast forward to the last case that I will talk about, and returning to school choice. So the big focus in Zellman versus Simmons Harris, a 5-4 decision, was whether religious schools could be included among the options available to public school students. 20 years later, the question of whether they can be excluded from participation is before the court on the basis of free exercise of religion. So Zellman was pure Establishment Clause. Here it's a clash between the Free Exercise Clause and the Establishment Clause. Almost every state, if not every state, does fund some children to go to private schools. Many of them under the Individuals with Disabilities Education Act, which requires a free, appropriate public education. And the courts have consistently ruled if the public schools can't provide a student a free, appropriate public education, they must do so in a private school. In fact, in some instances to the tunes of hundreds of thousands of dollars. So almost every state, if not every state, does provide some private school tuition. So the question was, what if a state excludes religious schools from that equation? So 3 cases go up to the US Supreme Court. The first one is a case from Missouri, where the state provides, and it's amazing what cases go up to the US Supreme Court. The state of Missouri provides grants for playground resurfacing. And any school, private or public, can get it, except religious schools. And they said, we can't give the money to religious schools because we have a Blaine Amendment that tells us we can't do that. Case goes to the US Supreme Court. The US Supreme Court says, you must allow this aid for religious schools. But there's a footnote in the opinion, and it's the most remarkable footnote I have ever seen. It says, this case applies only to playground resurfacing. We do not decide what it would be in other contexts. So a second case goes up, also unremarkable. Finally, a case goes up, and I'm so thrilled that you're having the superintendent of Maine, because it comes from Maine. So Maine is one of 2 states that has a number of areas that have no public schools whatsoever. So for well over a century, Maine has done what's called tuitioning, which is now called vouchers, that allows students in those localities to go to any private school, even schools in Canada, but not religious schools. And they argue that the Establishment Clause prevents them from doing that. The kids and the schools argue this is discrimination. This violates our free exercise rights, and the court, by a 6-3 vote, agrees, saying that once a state funds any type of private education, it cannot discriminate on the basis of religion. So think of how far we have gone from the 1940s to the 1920s, 2020s, from wall of separation to you cannot discriminate between the two. And when you combine that with the history and tradition test, which, by the way, I have been very critical. The court has been going off on this history and tradition thing. I am a textualist, and most of the court would probably describe themselves that way. But so much of the Bill of Rights and the 14th Amendment are a rebellion against history and tradition. So I am really uncomfortable with this approach. But nonetheless, that's where we are right now. And with the history and tradition test, it is hard to imagine a non-coercive government action being struck down under the Establishment Clause and the Free Enterprise Clause, if only, right? The Free Exercise Clause is becoming more robust as well, and has become essentially the intersection between the two of them has become a non-discrimination requirement. So that is where we are. That is somewhat of a lot of history to be crammed into however much time I've used here. But with that, I would love to hear your questions. And the only caveat is if you ask a question, please tell me your name and where you're from. And with that, thank you very much. Do you want to start or do you want?
You seem excited to jump in. So
Yes,
I'm
please.
happy to start with you.
Thank you for speak to us today. My name is Rohit Kaparia. I'm a first year master's in public policy student here, and I'm originally from a small town in southern Ohio called Wheelersburg. And I was curious, it seems like a lot of the arguments, either for or against vouchers at the Supreme Court level have focused on these establishment and free exercise clauses of the First Amendment. But I'm curious to hear from you if you think there are either other clauses of the First Amendment or other amendments in our Constitution that could also make good arguments either for or against vouchers.
So that's a really great question. Oh my gosh, one of my students raised. So, yeah, one of my students, I was so thrilled that she raised this because I had never heard this before. So one of the doctrines of the Supreme that the Supreme Court has developed over time is the doctrine under the free speech clause of prohibiting compelled speech, compelled government speech. This traces, it's a very noble doctrine. In my opinion, it traces back to West Virginia versus Barnett, where the court struck down the mandatory flag salute in an unbelievably eloquent decision by Justice Robert Jackson. And this has really broadened over time. And the most recent major case in this area is a case called, and no one knows how to pronounce this. I pronounce it Janus, other people pronounce it Janus, but it's in the area of compulsory unionization of public employees. And it says that if you force anyone to pay for union representation, that violates freedom of speech because it is requiring you to speak. So my student said, isn't that true of school vouchers too? You're forcing people to speak and to support things to which they disagree. And in fact, that was the early Establishment Clause jurisprudence in the funding area focused on exactly that from an Establishment Clause perspective, but pretty much the same doctrine. My response to that, after thanking her for coming up with such a creative idea, was it probably wouldn't work because of the doctrine of taxpayer standing. And that is in the federal courts under the case or controversy requirement, taxpayers do not have standing to challenge something that does not direct them personally. We don't have this in Arizona, I'm happy to say, but if it's unlike the union members, each of whom themselves are forced to pay discrete dues to the union, this is a differentiated harm that the court has consistently held is remedied in the political sphere, not in the legal arena. So I don't think that it would work, but it's a really intriguing idea. So the action is still in the state, under the state constitutions. And although the Blaine Amendment can no longer be used to thwart school choice, generally speaking, if a state court like mine decides a case based on independent state grounds, it cannot be appealed to the US Supreme Court. So at least 2 state Supreme Courts have struck down vouchers under discrete provisions of their own constitution. Florida struck down vouchers under what's called the Uniformity Clause, which is an education clause that appears in a number of state constitutions and forbids and requires a uniform public education, and the court held that vouchers made it ununiform. Other states have upheld voucher programs under that same provision, but Florida went the other way. Colorado struck down vouchers under a provision that appears in only 6 state constitutions that guarantees local control over education. And so vouchers are impermissible there. Interestingly, Massachusetts has what I call a super Blaine amendment, which is not only a Blaine amendment, which presumably can't be used now against school choice, but it's the only provision in the Massachusetts Constitution that says this can't be amended. That's how strongly the framers in the Massachusetts Constitution, and I'm aware of no other provision anywhere that says this can't be amended, but that's how strongly Massachusetts felt about it. So it'll be interesting to see if we get a Maine style case here in Massachusetts at some point. Great question. Thank you. Yeah.
Kind of related to that.
And you are?
I'm Eli, sorry. I'm
Eli.
from Texas, somewhere
Cool.
where vouchers are clear and present issue.
And the governor swears he has enough votes now.
We'll see, we'll see.
We will see.
In terms of like guardrails for like ESA voucher programs, a lot has been said about curriculum requirements or testing requirements. Kind of on the flip side of that question a little bit, would, like, obviously testing requirements would dictate curriculum. Would that constitute a violation of the free exercise clause by like mandating secular curriculum?
Such a great question. I don't know whether you're aspiring to law school or not, but you're thinking very much like a strategic lawyer over there. So I think that's exactly the next frontier. So interestingly, even under the Lemon test, the 3-part test, the third prong was, does the program create an excessive entanglement between the government and religion? So even under the old test, the word the court used to describe what was impermissible was surveillance. Basically, regulation that is so tenacious, so invasive that it would actually insinuate the government into the educational process. So that's always been, you used the great word guardrail. There's always been that guardrail that has minimized the risk of huge regulation. And a lot of schools worry about this hugely. And in fact, Christian schools in Texas, I've worked, or I used to work a lot in Texas, and they were no fans of vouchers for precisely that reason. Homeschoolers, same thing. But from the free exercise perspective, yes, I think that gives schools now a stronger weapon to use against government regulation. But that brings the political objection of, hey, we've got to make sure these schools are doing they're actually engaged in education. I do think that a mandatory core curriculum is almost certainly going to be permissible. But anything beyond that, including testing, probably would be vulnerable to a free exercise challenge. Great question. I feel like you asked if there was anything I wanted to touch. These guys are doing a really good job.
I love it. I'm looking at the group before I
Yeah.
jump in here. Yeah. Go ahead.
Hi, my name is Emma. I'm from New Jersey. I'm actually from Madison, so home of Drew.
Oh my God.
Yeah.
I was just there a little while ago.
Oh,
I had
nice.
forgotten how freaking beautiful that area
Yeah,
is.
I love the
So
Drew campus. We used to go
people
over there
don't think
for-
of it in
Yeah.
New Jersey as having really beautiful parts, but it definitely
Yeah.
does.
So my question is, I'm curious about the sort of national conversation that's going on right now about the potential to have the 10 commandments in classrooms. I'm curious your thoughts on how that has gotten as far as it has and where it's going to go.
Wow, that is a really good question. And my brain almost can't keep up with the jurisprudence at this moment. It's really, it has evolved so rapidly and so fundamentally. So, I think that it still would be subject to an establishment clause claim because of the potential coercive aspect. Especially if that was all you had on your board, and didn't have, I don't know, alternative religious texts or, actually, that's about all I can really think of. If a kid sees the word commandment, ordinarily they will, he or she will think that that's the rules, right? And if they are of their nature religious rules, I would think that that would probably flunk the coercion test. The court a while ago differentiated between K-12 and everything else. Basically, reasoning that children are much more susceptible to indoctrination than even college kids or adults. Like, you can't have a prayer in a school, but you can have a prayer at a city council. And kids don't know that they can object. So I think that, like, gosh, I wish I hadn't already written up my exam for my common law class, because I really think that's a really, I'm not even really seeing it as a close question, but that doesn't mean that the US Supreme Court wouldn't view it otherwise. Yeah, let's go.
Hi, so I'm Ana Sophia. I'm also from Texas. And I
Where
was
are you
actually
guys from, by the way?
Houston.
San Antonio.
Cool.
Yeah, so I was actually just
Great
teaching
jobs.
2 years middle school social studies before coming to HCAS.
Thank
And
you.
so
That's what got me out of teaching. It's not the easiest.
quite the age group.
Yes, exactly.
But so I was at this conference for history teachers over the summer, the National Constitution Center. And
That's
I
so,
was,
they do
it's a
such
fantastic
great
place.
programs. Yeah,
Really good curriculum resources online.
yeah.
But so we were looking at some cases at, in our own states or relevant to our districts. And I'm not sure if I'm remembering the specifics right. Maybe you can also help me out with this, Eli, but I think TEA put out a new common core curriculum that involved multiple excerpts of the Bible. And it's not that, public schools aren't being forced to implement the curriculum, but they are financially incentivized to use the common core curriculum. And so I'm wondering how can that be constitutional?
Boy, this is different from the old Common Core curriculum. So that's a really good question. So there is no question in my mind that the schools can teach the Bible as a general thing. So I was on the boards before I joined the court of basis schools and Great Hearts Academies. Great Hearts, I know, are in San Antonio now. And they're a great books curriculum, right? So they teach the Bible as one of the great books. They also teach the Quran. No question, you could have that. If you isolate it as the only religious book that you teach, that is really problematic.
And for me, it's the financial incentive.
So, and I was just about to get there. The fact that it's not mandatory, but incentivized, does not cleanse it of its constitutional sin, so to speak, to mix metaphors here. And I assume that's what what they're getting at. Oh, no one's required to do this. Boy, will you, you've all got a $2,000 pay raise, you know?
Which we need.
Yeah,
So-
yes, right. So so there's, because the Supreme Court has moved so much on the Establishment Clause, people are really pressing boundaries like they never have before. So for example, there is a case working its way up to the Supreme Court as to whether a charter school can be a religious school. And that is a public school. So I think all of these things are probably impermissible under current law. But will current law be be the law in 2 years? I don't know. And you've got in particular, the New York Times, when Kavanaugh was up, and you know, obviously things went off in a different direction on the Kavanaugh nomination. But the New York Times did this fantastic article about his Establishment Clause jurisprudence. And no one even gave it a second thought during his confirmation hearings because they were focused on other stuff. And he is a man with a plan with the Establishment Clause, and I don't know what that plan is. Justice Barrett also, you know, that's her passion. That was her passion as a law professor. So we've got, and certainly Justices Thomas and Alito will go anywhere they want to go. So there are four solid votes for almost anything in this area. And that's why you're seeing so much, you know, so much foment. But I take a narrow view of the Establishment Clause, but nonetheless, I do think that a school that teaches the Bible, and don't forget there's multiple forms of the Bible too, so presumably they're picking which version. I don't know, maybe they don't. Maybe that makes it neutral, right? The school can choose which version. But you know, it's hard for me, even with taking a narrow view of the Establishment Clause, to conclude that this does not establish. God, I'd just be a liberal on this court.
Eli, were you about to ask a
Yeah,
question?
I was actually going to ask you to expound a bit on that Oklahoma religious charter school case, because it does seem meaningfully different, directing funding to the school versus
Yes.
funding to students to make the election or
Yeah.
parents.
Yeah, so that used to be a huge criterion. Indirect, direct aid, and Professor Peterson probably remembers, I'm sure he remembers when this used to be done. So let's say you funded the Salvation Army to provide meals for the homeless. You used to have to take your crosses down. You used to have to religiously sanitize the environment. And the reason for that was that you were providing direct money and it could not be religious. That's why with Zelman, you know, we use the word indirect probably 30 times in our brief. I don't know where that distinction is these days. It hasn't come up in a case in a really, really long time, perhaps by virtue of the fact that it's simply not relevant, but it would have to come back big time in the charter school context. My guess is that the courts would say it's non-discrimination, it's neutral, so long as the government is not making them all religious, having a religious option is permissible. So we'll see. I am really anxious to see, you know, what that and all the years I've been saying charter schools are public schools, right? I may have to revise my Oh, and obviously they already are a hybrid because they are privately owned and managed, but they are public schools. And so the issue of public versus private comes up in the civil rights context, and other contexts as well. But the issue of religion, that was an exam question for my students a couple of years ago.
Professor
So
Peterson.
just to follow
Yeah.
up on the charter school, the argument is often made by those who say that this Oklahoma charter school, Catholic school, which is going to be offered online, is, or maybe already is offering online, is constitutional because of the Carson v. Macon decision.
Right.
So that actually you must allow it because
Right.
you're already creating secular charter schools. And these are private schools, so they are.
Yes.
These are private schools that are getting government money. And so once you've done that, then you can't deny that money to a religious school. So it's sort of ignoring the parental choice thing and focusing it more on, well, this is government money going to a
Private.
secular organization. So like with the Salvation Army has to be eligible as long as you've got secular organizations that are feeding the homeless. So it's the case, so.
He's got a career as a constitutional lawyer too,
Yeah,
but
so
he's gonna be too dangerous.
I've just been reading these folks, but so how do you navigate that?
No, I think your analysis is right. The Carson versus Macon, after two very narrow opinions, Carson versus Macon is no holds barred. It's pretty categorical decision. So I think that's the way the court would see it. We shall soon see.
I'm sorry, one.
No
quick
problem.
add-on. But like, are we going with that logic? Are we gonna see like religious schools based on like in the Native American context or in Texas in like the Islamic context? And if we don't, does that constitute a like violation of free exercise? We don't start to see like other religious.
So obviously they would have to try first. But there is, now that is a principle that started out in the Establishment Clause jurisprudence and is still firmly there. And that is that you cannot discriminate among religions. So this came up, I was hoping this case was going to come to my court so much, but City of Scottsdale had prayer in its meetings, and would invite various pastors to come and speak, or they self-selected, I can't remember. And then the Satanist church said, what about us? And so Scottsdale did what Scottsdale probably should have done under the circumstances. And that was to say, okay, nobody gets to do it. Because that would have been a really, really rough and tumble case. So, and that was one of the issues that came up very early in the voucher battle. What about, witchcraft schools, and I mean, for the conservative supporters of school choice, what about Muslim schools, and I was very clear from the outset, if you have a Catholic school, you must allow a Muslim school. And Native American, I mean, that's even, a stronger argument. So that's the thing about choice. If you are going to embrace it, you must embrace it. And, I think it was Ohio that included as part of its requirements that no school can teach racial hatred. Is that permissible or not? It's never been litigated to my knowledge. So there are potential mechanisms that you could use to prevent, I don't know, probably the schools that would be the most contentious would be, say, the Houston School of Jihad, right? There probably are neutral ways to prevent that from happening without straying into religious discrimination. But you may be opening yourself to a freedom of speech issue by so doing. Yeah.
I was curious what the sort of threshold or definitions around religion are, and if that's like a state level decision or federal level, it's like what are like in court cases, there must be like a definition of like what practices or what
Yes.
parochial schools like count as religion.
Yeah, so there is actually shockingly not a not a universal court test for that. And this cuts close to home because when my wife and I got married, the Commonwealth of Virginia said, refused to recognize my Buddhist brother's religious credentials. And I'm like, I don't have enough time to sue. So we had a judge, and then my brother presided over our civil ceremony, ironically enough. But that has been fraught with danger when governmental entities have sought to define religion. And generally speaking, what parties are required to do is to convince the court that they have deeply held religious views. So there's kind of a concept of a deity and kind of a regularization of views. So for example, if you belong to the Church of No Tax Payments, for example, they're not going to recognize that. But they don't typically trod more deeply than that, because that in and of itself could be a form of discrimination. But I can't think of a US Supreme Court decision that says that defines religion or takes up a state's definition of religion.
Just a quick statement, it's not a question. Massachusetts just allowed someone under the freedom of religion to wear a colander on her head for a driver's license picture.
Alrighty then. The cat people would be very happy to hear that, right?
Professor.
So, in Hawaii, they have charter school. And they have charter schools that are immersion ones, so you're taught Hawaiian language. There's a way of serving that language. And and they pray every morning before classes or extended prayer. And they pray, they ask the teachers for the gods to let them in and so forth. And is this a violation?
So, probably so. Probably so. Yes.
Nice succinct answer there. Do you mind if I jump in with one quick question here? So
Please.
you mentioned at the outset sort of the history of the voucher movement was rooted in efforts to segregate schools. And I'm surprised that sort of in the laying out of the more modern times of ESAs and vouchers, that you haven't introduced that as sort of an argument against it or an argument against it. Because rhetorically, sort of in the charter voucher ESA conversation, that is something that is constant, that is a constant refrain, that these policies are going to increase segregation. To what extent has that been introduced into the legal?
So it's only come up a handful of times, and the first time I saw it was in the Milwaukee program, where the NAACP was one of the plaintiffs. And the head of the NAACP chapter was elderly, and to him, that's all it meant. And I didn't fully appreciate that until I learned more about the history of segregate, or the history of using this as an alternative to segregation. And by the way, vouchers were struck down because this was perceived as a way of violating desegregation provision. So it had nothing to do with the Establishment Clause or anything like that. But it's pretty much dissipated. And I think the reason that it's dissipated is that the beneficiaries of school voucher programs are overwhelmingly Black and Hispanic. So it kind of loses its fervor. And I remember, Polly Williams, the legislator who championed the Milwaukee program, she just, and who is much younger than the head of the NAACP, she just had no patience for that whatsoever. She's like, we're turning a system of oppression into a system of liberation, so every now and then I would debate a teachers union person, and they would bring it up, but
Right.
then you point to the demographics. And in
Right.
fact, one of Professor Peterson's proteges did a study of the Cleveland school voucher program, who found that the program was more heterogeneous economically, racially, religiously, than the Cleveland public schools as a whole. And the US Supreme Court cited Jay Green
Yeah.
in its decision.
This is also Howard Fuller's sort of
Yes,
overarching.
Oh,
argument in
absolutely.
Milwaukee.
absolutely.
Do you have your hand up?
I was gonna, I guess, maybe sort of a response and a question to, Dr. Peterson's last point. My public high school in Southern Ohio, they had a Bible club, and it was my understanding that if they were to engage in Bible club activities on school grounds, if they had to do it before the school day started or after the school day ended, in which it was a generic sort of public building versus an actual school, I guess, like sanctioned activity. I don't know if that could have any sort of tie into the comment you made, and if that might change things. But I'm curious, I guess, then back to you, Justice Bolick, is that sort of probably along a court decision that they made that rule, or yeah, I guess sort of questions around constitutionality around, like, could they have done that? Was that, are they just being
If you were
careful?
late to school, you had to do it.
So yes, under the old Establishment Clause jurisprudence, having a religious class during school, a religious club during school hours would have been impermissible, even if it was purely voluntary. Having even in some places, even moments of silence were struck down because it was perceived that they were inherently promoting religion. Today, I think if you had any clubs that were allowed during school hours, you must allow religious clubs on an equal basis. That's again, those cases that the jurisprudence is so far outpacing these issues. I don't think probably most school districts are probably in violation of the current jurisprudence in some way and just haven't been able to catch up yet.
All right. Let's give Justice Bolick a round of applause. Really, really fun conversation. Thank you so much for being here and sharing those insights. And as a reminder, again, the final program on education policy and governance session will be Thursday, day after tomorrow, And it's going to be headlined by Stephen Bowen, the former Commissioner of Education in the state of Maine, which you referenced earlier.
Don't forget to ask them about that, Carson.
Yeah, you planted a nice seed there. Thank you again, and thank you all for being here.